Hello, Colorado Realtors. I'm Scott Peterson. Welcome back for another edition of Legal Bites. So it's 2020, and we're into February now, and one of the things that's been occurring, as it does every year, is the annual commission update course, the 4-hour mandatory course that you all have grown to know and love, has been in effect and being taught around the state since January 1st of this year. The 2020 version of that, and every year that leads, that class invariably leads. I see this real uptick in calls and confusion and frustration. And I teach the ACU myself, and so I've done enough this year so far to see that there's general confusion in the room as it relates to probably more than almost any topic, this one specific topic, and that's broker trust accounting requirements. And so this is a situation that would apply to you. Doesn't apply to a ton of brokers as a percentage of the population, but it would apply in the situation that you were a sales brokerage and you held earnest money on behalf of third parties for a sales transaction. Or I think even almost more commonly, because most brokerage firms don't hold earnest money, in my opinion, more commonly it happens if you're a property manager and you maintain a property management account, an operating account, and maybe a security deposit account on behalf of tenants, and you do that for a third-party property owner, for a client. And that's when this would apply, and so there's a section in the ACU that talks about it. I want to give a little bit of insight and input here. Broker trust accounting requirements. So again, very hot topic because it's come up in the annual commission update course. And this isn't a new requirement. This isn't something that it's based on a new rule specifically, although the rule numbers did change. It used to be Rule E1, which was all of the trust accounting stuff, was sort of buried at the front end of the E rules. It now, based on the recodification of the real estate commission rules, or restructuring of the real estate commission rules, it's now all of Chapter 5, and specifically 5.2 is where we get into this language that applies. And the teaching point from the slide in the annual commission update course in effect says that if you're holding money for other parties, if you're a licensed broker, you're holding money for third parties, then you need to make sure that what you're maintaining is an actual trust account, not just a trust account in name. And that has created some confusion because I think a lot of licensees, property managers and other brokers that might hold earnest money for third parties, they might go out to their bank and say, I want to open the Scott Peterson trust account or the Scott Peterson property management trust account or operating account and name it that account. But just naming the account doesn't specifically satisfy the requirement, because what's actually required is that you're creating an actual fiduciary or third-party fiduciary account. And that goes to the banking relationship that you're creating when you open up that account with the financial institution, with the bank that actually is going to maintain, presumably, that checking or other maybe savings account, whatever it might be. So what 5.2 essentially says is the brokerage firm must identify the fiduciary nature of each separate account in deposit agreements with a recognized depository. So your deposit agreements are probably, in the most common sense, referred to as the signature card or banking agreement that you would have when you go to open up an account. And I know this is a little bit difficult to read, but the challenge is that you need to make sure your bank is getting this right as they're describing the account. And we've also going to link here at the bottom. At the bottom, you'll be able to click on a fuller PDF of this, and to the extent that it might help you have a conversation with your lending institution about what you're trying to create, then feel free to open this PDF and print it out and take it to your bank with you. But what this essentially says is that in this case, the ownership of the account is a commercial account or other, and maybe it would say individual account, business account. That's not what you want for that ownership of the account to say. What you want for it to say is that it's a fiduciary or trust account. The ownership is that you as the account holder are holding that account as a fiduciary for some third party or holding it in trust for some third party. And so if you notice in the banking agreements or the banking relationship, that's what it makes you in compliant with the expectation that the deposit agreements with the financial institution are actually trust accounts. Not just because at the top of the thing you happen to call it a trust account or a operating account or a escrow account or whatever. That's just the name of the account, but if it says it's an individual account or commercial account or business account or whatever, doesn't necessarily create the fiduciary impact that is required. And the most simple way to look at this is that in an accounting or banking relationship, if you have, let's say, 5 accounts at a bank, and 2 of those you have named trust accounts, and you try and treat them as a trust account, and the other 3 are your personal business or your personal accounts, maybe your business accounts, and another family account that you might have, then what typically in the deposit agreements that you have with the financial institution, if it is just an individual or even just a business account, the lending institution, your bank, has the ability through the banking relationship, through the agreements that you have and the signature cards, to basically transfer money from one account to another account to cover overdrafts or non-sufficient funds or whatever you might have in one account. Well, imagine if that were to occur in a banking relationship where you've named something a trust account or a fiduciary account, but it's not actually a trust or fiduciary account. And the bank took money that belonged to your client, or maybe security deposit money that belonged to a tenant in a property management situation. They took that money and automatically withdrew from that account to cover your personal account overdrafts or non-sufficient funds. Well, you have, in that case, immediately, through no necessary fault of your own, commingled or diverted or converted or had some financial crime associated with that. And a fiduciary account shouldn't enable the bank to do that. So what do you do here? Check with your financial institutions. And like I say, you got to make sure you're talking to the right people at the financial institutions. I'm getting a lot of phone calls on the hotline from people who say, well, I've gone and talked to the bank, and they're talking to a teller or some sort of new account person maybe that doesn't exactly understand what you're specifically looking for here. So challenge your banks to make sure, and maybe ask to see the signature cards or deposit agreements that you have with the bank and see how they're titled. But it is important, if you're going to be compliant with what was E1 and now Chapter 5.2 of the Real Estate Commission rules, that you're making sure that if you have these kinds of accounts, because you're holding money for third parties, and you have to have an account, and in some cases multiple accounts, then make sure that they're compliant with the expectation of the rule. If you have questions, as always, the Car Legal Hotline is available for you, and believe me, I've been getting a ton of questions on this specific issue, so always feel free to reach out there, and otherwise we'll see you on the next edition of Legal Bites.